Hello, I'm Jennifer Martinez with Mariposa Realty Group, and the purpose of this video is to review with you the buyer representation agreement. In Texas, we have two options. We have the short form and the long form. On the short form, you can specify showing services or full services. The long form is specifically for full services. If you're not understanding what full services or showing services are, I did a previous video. Go find it on our YouTube page. It'll give you more information. It defines what that means. But for the purpose of this video, it's just going over a few simple things related to this long form. In Texas real estate, the buyer's representation agreement is the contract between the buyer and the licensed real estate agent. It defines the agent's roles and the client's roles, defines our responsibilities to the client. And the main thing that you need to understand is when you are in an agreement with an agent, you are owed loyalty, confidentiality, disclosure, and that your best interests always come first. The first page of this agreement, and I'll run through this briefly just so that you can see what it looks like, is going to be, it's going to specify the parties, right? So the client is the buyer or buyers, specifies the broker. It talks about the appointment, right? So it's an exclusive relationship that you're entering into to be able to acquire a property in the market area. The market area has to be specified. So because I work with clients that are looking in multiple areas, I typically just focus on a county, whether it's Starr County, Hidalgo County, or Cameron County. That's what I put in that section. It talks about the terms. So again, that's going to vary depending on what your needs and your timeline are. A lot of times you'll see an agreement for 6 months, sometimes a year, sometimes 3 months. Again, it's really very specific to what the client's needs are and what you both agree upon. It talks here a little bit about the broker's obligations and the client's obligations. On the next page, that's where it steps into compensation. So it outlines how the agent will be compensated for their services. Many times, sellers include buyer's agent compensation in the listing agreement. And so let's just say, for example, that you and your agent agreed to 3% compensation, which 3% of the sales price, it's always of the sales price. And you're looking at purchasing, going under contract on a $300,000 property. That's the sales price that you're going to offer. So your compensation to the buyer's agent at the 3% would be $9,000. Let's say that in the listing agreement, the seller is offering 2% compensation. So now there's a difference of 1%, right? You agreed upon 3%, seller is offering 2%. There's still 1% that is owed to the agent, and that would be your responsibility to bring that amount to closing. On leases, it's most oftentimes it's a percentage of the first month's rent, but it can be a percentage of all rents that are going to be paid over time. And on either one of these, it can also be specified as a flat fee. So again, those particular circumstances vary. These are several different options that could happen over the course of a sale or a lease. And again, one of the things that you need to know, it's clearly stated in here, is the broker will seek to obtain payment for compensation from the seller first. And if for whatever reason that cannot be obtained, then it would be the obligation of the buyer to pay that agent's compensation. And so then it goes through and it talks about what earned and payable is, and it talks about intermediary transactions, additional compensations. There are times when agents are paid a bonus when they bring a builder a contract, for example. Those bonuses should be disclosed up front so that you are aware of them and you agree to them. And again, there's a notice here specifically regarding bonuses. Down on page 3, it talks about the protection period. So let's just say that you entered into an agreement with an agent for whatever reason. Things just aren't working out. You do have the option to terminate that agreement. However, if that agent showed you several properties and you decided that you were going to go purchase a property that they showed you, they may still be eligible for compensation. if you're still within that protection period. Just keeping that in mind, I want you to know that. Hopefully, you're not going to have that experience where you need to terminate agreement with an agent. We have some amazing agents and brokers in our area in the lovely state of Texas, but there are times and circumstances where it is required. So just wanted to let you know that you do always have that option. Here, it specifies the county, so the county that it's referring to here would be where the broker would be paid, and it's always referring to the county that the broker is located in. Talks about representations, again, talks about intermediary status, non-intermediary status. Going forward, it gives you more information about competing clients, what happens if the broker represents other prospective buyers. That is defined here. Confidential information, mediation, default, has a lot of terminologies and definitions included in here. Addenda that may be included in the buyer's representation agreement, the information about brokerage services. That is a simple one-page form that tells you what the obligations and responsibilities of the brokerage are, and it is required by the state of Texas to be provided to you. The general information and notice to buyers and sellers, it has a lot of terminology and definitions related to real estate. It's really good information. Information about special flood hazard areas. There are some areas that it is a special flood zone and it requires flood insurance. So that's just a notice letting you know that there are those areas out there. For your protection, get a home inspection. We always recommend that you get a home inspection so you know any potential issues before you purchase the property. And then the wire fraud warning, because there is a lot of fraud everywhere nowadays, but even in the real estate industry, specifically related to wire fraud, we just want to let you know for your protection to make sure that you have your wire instructions and that you are sending it to the correct place, and you verify all of that prior to wiring that money. On the next page, there is a special provision section. If there's something specifically that was not included, a fact relevant to the agreement that needs to be included, that would be the space that it would go. Additional notices, and you would of course sign this page. As always, you have the option to have an attorney review this before you sign it so that you fully understand exactly what you are signing and agreeing to. I thank you for letting me break this down a little bit for you. I just think it's important that people understand there is a purpose in having these. Buyer representation agreements are not new, even though the regulation to have them signed prior to showing a property is new. This is something that the industry has been using for many, many years. But not all agents are talking about them so that people are fully understanding. Part of the reason why the lawsuit happened was because people felt like they were deceived or things were not disclosed. So we are trying at all costs to make sure that everybody fully understands what the purpose of these are. And instead of looking them as a negative, you understand that it's actually a positive. So you know exactly what you're agreeing to up front, and you have relevant information in front of you that you can refer to. So as always, if you have any questions, don't hesitate to reach out to us, www.mightycoastalrealtyrgv.com. Thank you very much and have a blessed day.